Welcome, everyone. My name is Stephen Lieboff. I'm the Program Manager of Education at People with Disabilities Foundation. I'm going to be your MC and moderator and general go-to guy if you have any questions about anything that's going on here. Today's seminar is called Autism Technology, Resources and Opportunities for Transitional Age Youth, an Interactive Discussion. This is the 11th seminar that People with Disabilities Foundation has put on. People with Disabilities Foundation was created with a mission of total integration of people with mental and/or developmental impairments into the whole of society. Our founder and legal director, Stephen Bruce, he's spent the last 25 years as an advocate for those with disabilities. He's a member of the California, Florida, and District of Columbia bars, and admitted to practice before the U.S. Supreme Court and the Ninth Circuit Court of Appeals.
As a lot of you know, the Rehabilitation Act of 1973 was the first law that Congress passed that protected the rights of disabled individuals. However, to be afforded the protections, they had to receive federal funds or be federal contractors. Then 17 years later, in 1990, the Americans with Disabilities Act was signed into law, and that applied to the private sector as well. This particular seminar is focused on transitional age youth, which means individuals who are getting out of high school and are no longer being entitled to all those resources, benefits, and entitlements in elementary and secondary school. Some of them may go on to post-secondary colleges, universities, or vocational schools, or apply and engage in employment. The disorder we're focusing on today is autism spectrum disorder, which has been evolving, as a lot of you may know, over the past several years into a spectrum which is inclusive of anywhere from very mild Asperger's to severe autism, and it's continuing to evolve. And fortunately, we do have a psychologist, Dr. Pederson, who will help give the medical definition of autism and its resulting functional limitations, which are always necessary, whether you're applying it to college, to employment, to housing, to healthcare, or education. It's not enough to know just the diagnosis. As to this disorder, assistive technology is particularly important, and we have several speakers who will address different kinds of technology.
One of the main subjects that we're going to touch on today is this transitional age youth, or TAY population. The TAY population is in a very tenuous position, as a lot of the services that they're allotted as children sort of run out. They age out of those services. And so a lot of the information we're going to go over today is going to be resources and opportunities available to this population, to combat this falling off the cliff sensation that a lot of people have described. So we're honored to have a wide range of speakers, and in order of appearance, they are clinical psychologist Dr. Loren Pederson, who will be discussing the diagnostic overview and functional limitations of persons on the autism spectrum. Allison Wang, staff attorney at PWDF, she'll be giving a legal overview of the obligations and reasonable accommodations in employment and education. Laura Shoemaker, author of A Normal Guy Growing Up with Autism, frequent contributor to the SF Gate, and mother of an autistic son. She will be speaking about her experiences as a mother and advocate of a transitional age autistic son. Andy Axel, father of an autistic son and co-founder of the Specialist Guild, a nonprofit social enterprise focused on helping people with Asperger's into careers that recognize their strengths and intelligence. Andy will be speaking about employment and how his agency is using technology to increase employment opportunities. Jennifer McDonald-Peltier from the Center of Accessible Technology will be speaking about the use of tablet-based programs as assistive technology for autism spectrum disorder individuals. Alicia Contreras, assistive technology educator at the Independent Living Resource Center of San Francisco, will be talking about and demonstrating the Technology Lending Library program. Damina Stanfield, Marie De Leon, Karen Looker, and Brian Foth, along with a contingency of students, will be representing Cal State University East Bay and speaking about the College Link program, a program developed to assist students on the autism spectrum navigate post-secondary education. And finally, Zoe Gross, student Vassar College, activist with the Autistic Self-Advocacy Network, and mastermind behind a very entertaining blog, illusionofcompetence.blogspot.com, will be speaking about her experiences as a self-advocate and how the technological landscape has shaped her experience as an advocate.
What I'm going to try to do is to give you a fairly brief clinical bird's eye view of what we call the autistic spectrum disorders today, and hopefully you'll go away with a better understanding of what those are about. The diagnosis, treatment, and causes of autism have gone through many changes since I saw my first autistic patient many years ago as an intern in psychology. At that time, I was told by the clinic director not to treat this patient, but only to diagnose him. When I asked why, he said, well, patients like these are untreatable, and most of them need to be institutionalized. I was surprised by that because in those days I thought everybody was treatable. Actually, I still do. So I asked the director if I could try to treat him anyway. And with an indulgent smile, he looked at me and said, what in the world will you do with him? He's 4 years old, a child schizophrenic, has never said a word in his life, and all he does is flap his arms. My reply was, well, he doesn't talk and I'm nearly deaf. Maybe I can try something different with him. To my surprise, the director said, okay. And the rest is a long and interesting story for another time. But that child was never institutionalized. There's a debate today about whether autism is one disorder or overlapping disorders. We in the mental health profession have to take our criteria from the Diagnostic and Statistical Manual of the APA. It's called the DSM. In the current edition of the DSM-4, autistic conditions are subsumed under an umbrella of 5 so-called autistic spectrum disorders, or ASDs. It's called that because at the moment they represent a spectrum of neurodevelopmental disorders with similar symptoms, but with varying severity of those symptoms and varying numbers of those symptoms. Autistic spectrum disorders in children, once considered a rare disorder, now affect 1 in 88 children, 1 in 54 boys, 1 in 252 girls. Its most general definition is that there are severe disorders of communication and behavior. Their various problems impair their ability to understand other people, what they see, what they hear, and in general, even what they sense. Common symptoms include difficulty understanding social relationships, severe restriction of activities and interest, and restricted and/or repetitive behaviors, as well as the absence or impairment of speech. Many are diagnosed by 3 years of age. Their IQs vary considerably. In one study, 55% had IQs less than 70, 16% less than 50, 28% had average IQs, and only 3% were above average. In addition, within the spectrum, there are also those who are called autistic savants, which we don't have time to go into today. So there are five. What are the five disorders that are in this spectrum? One is called autistic disorder. The second one is called Asperger's disorder. Third is called pervasive developmental disorder, not otherwise specified. Fourth, the fourth is Rett's disorder, and the fifth is what's called childhood disintegrative disorder. What I'm basically going to try to do is give you kind of an overview of each of these disorders and what their basic prognoses are. The first one is called classical autism, or autistic disorder. This is the largest and thought to have the most severe symptoms. Their social interactions often lack appropriate eye contact, facial expressions, or other gestures commonly used to participate in normal, quote-unquote, normal social relationships. As a result, they are often unable to maintain appropriate relationships with their peers because of their difficulty initiating or sharing spontaneous activities with others. Their delayed or sometimes lack of spoken language makes it difficult, sometimes impossible, to initiate or sustain conversation, and because their speech is often stereotyped, repetitive, or just idiosyncratic. Other behaviors in the autistic disorder are an all-encompassing preoccupation with one or more restricted areas of interest, inflexible adherence to routines or rituals, and repetitive motor patterns such as hand or finger flapping. The second one is called Asperger's disorder. They have many of the same or similar symptoms as autistic disorders, but they're not considered to have the autistic diagnosis because supposedly they have no cognitive deficits and can speak normally. There's a big question that we can't go into about cognitive deficits, but they definitely have them. It's just become part of what's used in the DSM-4 to diagnose people. Okay, the next one is pervasive developmental disorder. We call this PDD. It's also known as subthreshold autism or atypical autism. Early signs are often visible in babies, but a diagnosis is not usually made until around the age of 4. PDD is used when there are severe and pervasive developmental impairments in communication, social interaction, verbal and nonverbal communication, and or when stereotyped behavior, interests, or activities are also part. Some consider PDD to be milder than typical autism, but this is not always true. Some symptoms may be milder, but then again, they may have other symptoms that are more severe. The fourth one is called Rett's disorder or Rett syndrome. This occurs in 1 in 10,000 girls. Their earliest symptoms emerge around the age of 6 to 18 months. It begins with normal head circumference at birth and up to 5 to 48 months. Then there is a startling deceleration or reduction of head growth. In fact, in autistic, there's about a 20% incidence of macrocephaly or enlarged brain, but in Rett's, it's just the opposite. Let's see. They have normal levels of psychomotor development until they're about 2 or 3. In fact, these girls look very normal up until about 2 or 3. But then their normal developmental progress stops, and they regress into these autistic symptoms. The children, almost all girls, withdraw from social engagement. They lose their expressive and receptive language, develop repetitive movements such as hand wringing, but they also develop poor coordination and walking, and sometimes in trunk movements. And so they actually begin to look more like the classic autistic patient. In the 1990s, researchers discovered that Rett syndrome is caused by mutations in the MECP2 gene, which encodes protein important for neuron function. Because this gene is a dominant and sex-linked on the X chromosome, that is the reason that the disorder primarily affects females. Males who have a damaged copy of this gene on their single X chromosome rarely survive. Most of them die in the womb. Okay, the last one, childhood disintegrative disorder, particularly devastating disorder. It's the rarest of the 5, and like Rett syndrome, their lives also begin with normal development. For at least 2 years, their communication, social relationships, and play appear perfectly normal. But then between the ages of somewhere between 3 to 10, they suddenly begin to deteriorate. As that happens, they rapidly lose their social skills, language, sometimes bowel and bladder control, and other motor skills. They also begin showing classic autistic symptoms. Unique to the onset of this particular disorder is a period of intense anxiety and terror just as the disease begins to progress. Okay, so those are the 5 overviews. And basically, let me tell you a little bit about the prognoses. Prognoses in general, for those on the spectrum, these are problems that generally last a lifetime. Their long-term outcomes vary, but all of the disorders definitely leave lifelong impacts. To date, there are no known cures. Individual outcomes depend on, which doesn't mean to say there can't be improvements. It's just that there isn't a cure as such, because there can be tremendous improvement. Individual outcomes depend on the number and degree of their overall impairments and the intensity, kind, and timeliness of their educational and treatment modalities. Current trends based on increased knowledge of how and when to educate these children emphasize building skills and abilities quickly in order to prepare young adults to work and live in the community, and in some cases to even pursue higher education. As far as autistic disorder specifically goes, in the past, many individuals with autistic disorder lived in institutions as adults. The severity of its outcome often depends on IQ level, the degree of impairment in social interaction, and the lack of appropriate communication. Earlier interventions that include special education, behavior modification, speech therapy, psychotherapy, all can change the outcome positively. The best predictor of outcome in the autistic disorders is how it progresses from the year it's diagnosed. In other words, from that year following the making of the diagnosis. Those with fewer symptoms obviously do a lot better. Those with more severe symptoms have a much harder time of it. And then in Asperger's, with early intervention and effective treatment, many Asperger's children can learn to cope well, but find still social situations and personal relationships to be sometimes quite challenging. Many adults are able to work successfully, often in mainstream jobs, although they may need encouragement and support to maintain an independent life. In pervasive developmental disorder, the PDD, their progress is markedly better if they develop and use language before the age of 5. Those who proclaim themselves recovered, even those continue to have some difficulties with subtle social processes. So as adults, their range of outcome varies greatly, and is expanded by, again, early intervention, special education, speech therapy, psychotherapy. In Rut's disorder, the age of onset and severity of symptoms varies from child to child. Despite the difficulty with the symptoms, those with Rett syndrome continue to live well into middle age and beyond. And often their early loss of social interaction may actually redevelop at a later point. Because the disorder is rare, very little is known about either its long-term prognosis and life expectancy. One new hope is that there already has been a genetic reversal in a genetic mouse model where female mice who had been given this defective gene were fed tamoxifen, and that actually reversed the neurological effects. So it's in mice, but it's still encouraging. CDD, childhood disintegrative disorder, has the worst prognosis because once their skills are lost, they're usually not regained. 20% of these children regain the ability to speak in sentences. Most adults remain dependent on full-time caregivers or are institutionalized. So in 2013, next year in May, there's going to be a new edition of the DSM coming out called DSM-5, where interestingly, and you probably already asked yourself this question, if there are so many different categories of this disorder, and they have so many overlapping symptoms, why don't they all just fit into one kind of more or less neat category? Well, that's actually the goal of the DSM-5 as far as autistic spectrum disorder goes. One of the things that we're going to see is that autistic disorder, PDD, Asperger's syndrome, childhood disintegrative disorder, all of those will be under one diagnostic category, which will look something like this. It's not finished yet, but it will look more or less like that. And Rett syndrome will not be included, and one of the reasons is that there's such a clear genetic basis for Rett syndrome, or at least that's beginning to be seen as such. So one of the things that I find interesting about this group of disorders comes from some of the new information that's coming out in brain imaging studies, EEG, QEEG, and these are helping us unravel the enigma of so many apparently related and unrelated symptoms of the ASDs. What is evolving is a new brain-based interpretation of ASDs, because you see, when you look at this DSM categories, all you see are behavioral descriptions. There is no medical test for this disorder. It's basically just describing symptom upon symptom upon symptom, whether a given individual has that or not. But with the brain studies, what we're beginning to see is that there can be brain-based interpretations which make it easier to understand both the similarities and the differences within the ASD spectrum. In addition to those, we can also begin to look at things like ADD, ADHD, Tourette syndrome for these biomarkers, so to speak. And one good example of this is in what we call coherence studies. We're beginning to see in coherence studies that many of the symptoms of the spectrum are the result of abnormal connections, or what we call coherence problems, that occur between four primary brain areas, as well as the integrative center in the medial prefrontal cortex, that's right in front of the brain. These areas all subserve the functions of emotional social behavior, memory, perception, language, and motor behavior. And these are obviously the symptoms where the ASDs occur. Okay, that's all I'll say. Thanks very much for listening.
My name is Allison Wang. I'm a staff attorney at Disabilities Foundation. I am here today to provide a general legal framework explaining how the law protects people with disabilities such as autism in employment and post-secondary education. There are a number of laws providing protections to people with disabilities. There are federal laws such as the Americans with Disabilities Act and Section 504 of the Rehabilitation Act. And there are also state laws such as the California Fair Housing and Employment Act, or FEHA, the UNRU Act, and the California Disabled Persons Act, sort of mirrors the ADA. In some areas, California law actually provides more legal protection or is more comprehensive. In other areas, federal law may be more helpful. That's going to exceed the scope of this talk, but I just wanted to let you know that that's out there. I'd like to start with federal laws regarding employment. The ADA prohibits discrimination in all employment practices, including job application procedures, hiring, firing, advancement, compensation, training, and other terms, conditions, and privileges of employment. It applies to recruitment, advertising, tenure, layoff, leave, fringe benefits, and all other employment-related activities. To be protected by the ADA, one must have a disability or have a relationship or association with an individual with a disability. So let's go to the actual ADA definition of disability. Under the ADA, an individual with a disability is defined as a person who has a mental or physical impairment that substantially limits one or more major life activities, a person who has a history or record of such impairment, or a person who is perceived by others as having such an impairment. Persons discriminated against because they have a known association or relationship with an individual with a disability are actually protected. Let's see if I do this right. No. All right, I did it right. All right. Major life activities include, but are not limited to, walking, seeing, hearing, speaking, breathing, learning, working, caring for oneself, and performing manual tasks. As our last speaker said, autism is a spectrum disorder. Accordingly, the functional limitations of an individual on the spectrum will determine whether or not they meet the definition of disabled under the ADA. Not all people on the autism spectrum will meet the definition of disabled. More specifically, a qualified individual with a disability is a person who meets the skill, experience, education, or other requirements of an employment position that he or she holds or seeks, and who can perform the essential functions of the position with or without reasonable accommodation. An individual with a known or disclosed disability will not be considered unqualified simply because of inability to perform marginal or incidental job functions. If the individual is qualified to perform essential job functions, except for limitations caused by a disability, the employer must consider whether the individual could perform these functions with a reasonable accommodation. Now, a reasonable accommodation includes modifications or adjustments to a job or the work environment that will enable a qualified applicant or employee with a disability to participate in the application process or to perform essential job functions. So it's important to note that it applies in pre-employment settings as well. Reasonable accommodation also includes adjustments to assure that a qualified individual with a disability has rights and privileges in employment equal to those of employees without disabilities. Some examples of reasonable accommodation, especially relevant to folks on the autism spectrum, include, for the pre-employment stage, allowing an interviewee to communicate in written format only with pre-submitted questions, allowing an employee to use assistive devices, allowing an employee to provide written responses in lieu of verbal responses, allowing an employee to bring an advocate to performance reviews and disciplinary meetings, adjusting supervisory method by modifying the manner in which conversations take place, meetings are conducted, or discipline is addressed, allowing alternative forms of communication between coworkers, such as email, instant messaging, or text messaging, or appropriately modifying examinations, training, or other programs. This is especially important because an agency may not use employment tests or other ways of selecting employees which tend to screen out qualified individuals with disabilities, unless the agency can prove that the test score or selection process is related to the specific job in question and that other testing or selection methods are unavailable. In other words, the employment test must reflect an applicant's or employee's ability to perform the functions of the job, rather than focusing on an individual's disability, unless the disability is directly related to the skills being measured for the job. Reasonable accommodation may also include reassigning current employees to a vacant position for which the individual is qualified if the person is unable to do the original job because of a disability, even with an accommodation. However, it's important to note that there is no obligation to find a position for an applicant who is not qualified for the position sought unless there exists an open position for which they are actually qualified. In selecting the particular type of reasonable accommodation, the principal test is that of effectiveness, or whether the accommodation will provide an opportunity for the person with a disability to achieve the same level of performance and to enjoy benefits equal to those of an average, similarly situated person without a disability. It's important to remember that the accommodation does not have to ensure equal results or provide exactly the same benefits, or even the benefits that were requested, the same benefits that were requested. An employer is only required to accommodate a known disability of a qualified applicant or employee. The requirement is generally triggered by a request from the individual with a disability. If the individual does not request an accommodation, the employer is not required to provide one, except where an individual's known disability impairs his or her ability to know of or effectively communicate the need for an accommodation that is obvious to the employer. So this means that legally, an applicant or an employee doesn't need to disclose their disability unless they want an accommodation. And this is a strategic issue that is different for everyone. So there are some limitations on the employer's obligations to make reasonable accommodation. The individual with a disability requiring accommodation must be otherwise qualified, and the disability must be known to the employer. In addition, an employer is not required to make an accommodation if it would pose an undue hardship on the operation of the employer's business. Undue hardship is defined as an action requiring significant difficulty or expense when considered in light of a number of factors. These factors include the nature and cost of the accommodation in relation to the size, resources, nature, and structure of the employer's operation. Undue hardship is determined on a case-by-case basis. An accommodation that changes the underlying function of a program or a business is an undue hardship. There are some other considerations as well. Under the ADA, an employer is not required to reallocate an essential function of a job to another employee as a reasonable accommodation. An employer can hold employees with disabilities to the same standards of production and performance as other similarly situated employees without disabilities for performing these essential job functions with or without reasonable accommodation. However, if the ability to perform marginal functions is affected by the disability, the employer must provide some type of reasonable accommodation, such as job restructuring, so long as they can satisfactorily perform a job's essential functions. All right, so there are some other laws that also come into play. One of the other major federal laws is Section 504 of the Rehabilitation Act. Section 504 prohibits discrimination on the basis of disability in programs conducted by federal agencies, in programs receiving federal financial assistance, in federal employment, and the employment practices of federal contractors. The standards for determining employment discrimination under the Rehabilitation Act are essentially the same as those used under the ADA. Then there is California state law, the Federal Employment and Housing Act. The FEHA is the principal California statute prohibiting employment discrimination covering employers, labor organizations, employment agencies, apprenticeship programs, and any person or entity who aids, abets, incites, compels, or coerces the doing of a discriminatory act. It prohibits employment discrimination based on a number of categories not covered under the ADA, as well as protection for people with physical disability, mental disability, or medical conditions. The FEHA also prohibits retaliation against anyone for opposing any practice forbidden by the Act, or for filing a complaint, testifying, or assisting in proceedings under the FEHA. So one of the neat things about FEHA is it covers California employers with 5 or more employees. Only 1 employee is needed for a disability harassment claim. Under the ADA, it's 15 employers. Like the ADA, employers must make reasonable accommodations for applicants and employees with disabilities unless the accommodation would impose an undue hardship on the employer.
Since you mentioned that the ADA also protects in pre-employment settings, what about when there's employment testing? And let's say we have a student with a disability who requires, let's say, time and a half in the normal academic setting, and it's determined that they would need time and a half to complete a test in order to be considered for employment. Is that, does that fall under this category, especially if the employer states it is a timed test for a reason?
What I think she asked is, can an employer give additional time for a pre-employment test? Yes.
Is that
That is a reasonable accommodation, yes.
okay? Is that required even if the employer was to state that the test is timed?
The test is timed.
Yes.
Yeah, okay, good. Thank you.
Hi. Do all of the laws that you just described apply as well to unpaid employment, like volunteers? Because there are employment situations that are both paid and unpaid, and particularly a lot of people with disabilities often have volunteer-type jobs. So do all these things apply to unpaid situations?
You know what, that is a good question, and if I can get back to you at the end of the seminar. All right, ready for post-secondary education?
Yes.
All right. So there are 2 pieces of federal legislation, Section 504 of the Rehabilitation Act and the Americans with Disability Act, that apply to post-secondary programs. Section 504 applies to all entities, including post-secondary educational programs that receive federal money, while the ADA applies to every post-secondary educational program that is pretty much not associated solely with a church, private organization. For all intents and purposes, since most post-secondary colleges, most colleges and universities take some sort of federal funding, the protections are essentially the same. Under these laws, individuals with disabilities who are otherwise qualified to participate in post-secondary educational programs must be provided that opportunity. A qualified individual with a disability may not be denied admission or be subjected to discrimination in admissions or recruitment solely because of his or her disability. There is, however, an individual must be able to meet the technical and academic qualifications for entry into the school program or activity despite his or her disability in order to be considered otherwise qualified. So, for example, a nursing school may impose valid physical qualifications for admission to a clinical program. It need not waive important academic requirements or provide an interpreter so that a person with a hearing impairment can participate in the program when the ability to hear is validly deemed essential to successfully participate in the clinical program. And there is a famous case on that called Southeastern Community College versus Davis. It's a Supreme Court case. The citation, for any attorneys who are interested, is 442 U.S. 397. Discrimination or in admission or retention on the basis of a disability includes not limiting the number or proportion of individuals with disabilities who are admitted, not using any test criteria that disproportionately discriminates against individuals with disabilities, selecting admission tests that reflect the aptitude of individuals with disabilities rather than their sensory, manual, or speaking limitations, not inquiring about the existence of a disability during the admissions process unless it is clearly stated that the information is voluntary, will be kept confidential, and is being used solely in order to monitor the school's compliance with non-discrimination laws. Another key focus of ADA in Section 504 related to students with disabilities in post-secondary settings is the application of academic adjustments. A post-secondary education program which receives federal funds must modify its academic requirements if necessary to ensure that a person with a disability is not discriminated against, and must provide auxiliary aids such as readers, interpreters, and adapted classroom equipment. I believe later on we'll be talking about some of the new technology that is part of this. However, educational programs do not need to modify requirements which are essential to the program. In addition to academic supports, Section 504 and the ADA prohibit colleges and universities from discriminating against qualified students with disabilities in housing, financial assistance, physical education and athletics, counseling and placement services, and social organizations. So non-discrimination in housing is important. If a school which receives federal assistance provides housing for students who do not have disabilities, it must provide comparable, convenient, accessible housing for students with disabilities at the same cost. Also, non-discrimination in financial aid. A school which receives federal assistance may not, on the basis of disability, provide less financial aid, limit eligibility for financial aid, or discriminate in any other way against applicants with disabilities and recipients of financial aid. Special scholarships and awards which may discriminate are valid only if the overall effect of the award or scholarship is not discriminatory on the basis of disability. For example, it might not be considered discriminatory to deny a varsity football scholarship to an individual with a neurological disorder, but it would be discriminatory to deny a diving team scholarship to an individual solely because he or she has a hearing impairment. The decision must be based on comparative athletic ability, not on the presence or absence of a disability. Last, we have discrimination in non-academic services, which is also prohibited. A recipient of federal funds or assistance may not discriminate on the basis of disability in providing physical education courses and athletic programs, and must provide qualified students with disabilities an equal opportunity to participate. A school may only offer separate or different physical education and athletic programs if they're not discriminatory, and if qualified students with disabilities have the opportunity to participate in the regular programs as well. Personal, academic, or vocational counseling must be provided without discrimination as well. It is discriminatory to counsel students with disabilities to pursue more restrictive career objectives than non-disabled students with similar interests and abilities. That concludes my overview of the main parts of post-secondary education law that are relevant. Thank you for your kind attention. Are there any questions? Great.